Hi, everybody. Good afternoon and good morning, depending on where you are. Welcome to what you need to know about the USPTO's post-registration audit program. My name is Lauren Amanda, National Sales Director here at Alt Legal. A few announcements before we kick things off. You've probably heard all of this before, but you see the code of conduct. Please use common sense. Don't be a jerk. If you see anybody violating this, just let us know. If you are watching this session live, good news, you may qualify for CLE credit. Keep in mind you're required to, we have to keep detailed attendance records, and it'll include whether or not you're in the session and whether or not this is the active tab. So keep everything active, and we'll also announce a code at random during the session. I'll pop back in to do that. Take note of the code to include on your survey. In order to qualify for CLE credit, you must be in the session the whole time and have the code. After the conference, we'll distribute CLE information about the sessions you attended. Note that our CLE provider is only offering credit for the live presentation, so if you are watching this recorded session, it does not qualify for CLE. As with our other sessions for chat, for Q&A, you're welcome to use the chat on whichever platform you're using. Speaking with fellow attendees, to get questions or comments directly to the presenter, please use @presenter to highlight it, and we'll make sure it gets over to Allison. And this session has been brought to you by our generous sponsor, Fross Zelnick Lehrman Zissu. Yay, Fross Zelnick. And now I get to introduce the one and only Allison Ricketts. Allison is a partner at Fross Zelnick. Her practice focuses on trademark clearance, registration, and protection. She has handled thousands of trademark applications and registrations before the USPTO. Allison is a member of Compumark's Customer Advisory Panel and is a member of the Trademark Office Practice Committees of IPO and the AIPLA. She's a 1993 graduate of Columbia Law School and a certified advanced open water diver. Huh, so cool. So with that, Allison, I'm excited to pass it over to you, and I'll pop back in with that CLE code.
Okay, thank you so much.
All right.
Yeah, I think that the worst thing about the pandemic, or a bad thing about the pandemic, has been not being able to get in the water and do the diving. Because if you go more than 6 months or so, you have to go back in a pool and do a refresher. So even if you are an advanced open water diver, it's like you're starting all over again. Anyway, hello, everyone. Good afternoon. Thanks for joining me. The USPTO likes to claim that the Federal Trademark Register reflects commercial reality of marks used in commerce. It constantly touts the integrity and accuracy of the register as a reason underlying much of its policymaking. Now, of course, the register does not actually reflect commercial reality because many marks can be registered without any requirement to prove use prior to registration, because marks can be registered based on a home country registration under Section 44 and by means of the Madrid Protocol under Section 66. But in order to maintain those registered rights, every registrant must file periodic declarations of use. Goods and services that are not in use in commerce, but that are maintained and are not deleted at the time of the maintenance, are known as deadwood. As part of its effort to reduce deadwood on the register, the USPTO implemented a new post-registration audit program in 2017. So today we'll talk about what the program is, how to prepare your client to pass the audit, and how to respond to a post-registration audit office action. Now, if you watched the excellent presentation yesterday by Ed Timberlake about non-traditional trademarks, I'm sorry to tell you that this presentation will not be as entertaining as his was, but I will from time to time be getting up on my metaphorical soapbox to be lecturing you about best practices and the like. So why was the audit program adopted? Section 8 of the Lanham Act requires the filing of a periodic declaration of use or of excusable non-use to maintain a U.S. trademark registration. The necessary declaration must be filed either between the 5th and 6th anniversary, and then with every 10-year renewal, meaning between the 9th and 10th year anniversary, the 19th to 20th year anniversary, etc. You can also file during a 6-month grace period that's automatic after the deadline, so long as you pay an extra fee. The same filing is required for registrations that issued pursuant to an extension of protection of an IR and international registration pursuant to the Madrid Protocol. That requirement is found at Section 71 of the Lanham Act. So technically those are called Section 71 declarations, but I'm just going to refer to them throughout as Section 8 for ease of making it a short reference. Trademark owners submit one specimen per class with each of the Section 8 declarations that are filed. So here is the language of Section 8 of the Lanham Act. Basically, the requirements are the affidavit must state that the mark is in use in commerce. It must set forth the goods and services recited in the registration on or in connection with which the mark is in use in commerce. It must be accompanied by such number of specimens or facsimiles showing current use of the mark in commerce as may be required by the director. At this point, the regulations require one specimen per class showing use on one product or service in the class, and it must be accompanied by the fee. The statute also provides for a declaration of excusable non-use, but we're not going to talk about that today. For a number of reasons, many registrants do not delete goods and services on which the mark is not being used when the Section 8 declaration was filed. Instead, they maintain the registration for the entire class if they had a specimen of use for at least one item in the class. Inaccurate use claims contribute to a cluttered trademark register and diminish the register's utility for business and the public because the post-registration maintenance are intended to clear unused marks or deadwood from the register. So the USPTO suspected that that was not happening. And so in 2012, they commenced a pilot program that randomly selected 500 registrations for audit. Each registrant was required to provide specimens of use for 2 additional items in each class, and those were selected by the Trademark Office examiner. What happened? Well, the results were not good. Many registrants failed the audit. More than 50% were unable to provide specimens of use for the 2 additional items that they claimed. Specifically, I've got a slide here that shows the results of the pilot program that the Trademark Office distributed at the end of the program. The far right column says the percentage of registrations selected for the pilot who were unable to verify their previously claimed use in their Section 8 declaration. So remember, the declaration would have been filed just a few months prior to this office action issuing requiring the additional evidence. You have 6 months to respond, and people were not able to provide the additional 2 specimens. Something that the office and the bar was curious about was to what extent the people failing the audit were going to have been originally based on use versus originally based on a home country registration or Madrid Protocol, where there had never been any requirement to file a claim of use prior to this. But that isn't really what the results showed. The very first row there shows that registrations that were originally based on both 1A, claim of use, or well, just on Section 1A, 45% of those registrations were unable to provide the additional proof of use. For registrations that were originally based on 44E, 65% were not able to provide the additional evidence. Those that were based on Madrid Protocol, 71% were not able to file the additional evidence of use. And finally, a category of use-based and 44E, 69% were not able. So the USPTO had to then reflect on what to do about this now that it knew and it had concrete evidence of the number of people who were not complying with the statutory requirements. It was felt to be inequitable to make a new requirement for additional proof of use to apply at the pre-registration stage, since that burden would fall inequitably on applicants on who were use-based as opposed to relying on other bases. But all registrants must file the maintenance declaration. So that it was felt that that was the better time to go about doing an audit. So why might a registrant file a declaration that incorrectly claims use in commerce? Why are people making these claims that turn out to be not supported? Well, I think it's a combination of a lot of factors. Since only a single specimen per class is required, I think it's very easy for people, including attorneys, to think that that's sufficient, that and they don't really pay attention to the requirement that it actually be in use for everything claimed. Another issue is, how recent does the use need to be that you're relying on? There isn't a rule that says exactly how recent it must be. And so I think sometimes perhaps people rely on a use that was quite, that was quite some time ago. So that, if the office then asks for additional evidence for 2 more things, maybe they don't have that at a current time to provide. Not understanding what constitutes use in commerce. So the statutory definition of use in commerce is that for goods, the mark is placed on the goods and the goods are sold or transported in commerce. For services, the mark is displayed in the sale or advertising of the services, and the services are rendered in commerce. And finally, use under goods or services must be in the ordinary course of trade and not merely to reserve a right in the mark. Now, the U.S. encourages pro se use of its system. It kind of prides itself on having an easy to use system so that entrepreneurs can, obtain trademark rights without having to go to the expense of hiring counsel. But I think that the definition of use in commerce in particular is not something that is intuitive to a lot of people, and they're not aware of all the case law that goes into a determination of use in commerce. And they don't even know that commerce is referring to the Commerce Clause and, all commerce that can be regulated by Congress. That's what we learn in con law in law school. We learn about, all the cases involving motels and restaurants along interstate highways and why that was use in commerce and that sort of thing. So, for example, I believe that a number of pro ses might, for example, think that offering or offering goods on a print-on-demand store might be use in commerce, but it isn't use in commerce unless someone has actually purchased some merchandise that the print-on-demand vendor actually prints the mark on and ships it to them. Then there's also a lot of questions where it's really not, I wouldn't say that there's definite law on it. Let's say that the goods are no longer produced by the trademark owner, but they're still being sold, by the trademark owner's retailers that it, regularly sells through. Consumers are still buying those goods under that mark. Is that use? Are you allowed to rely on that? Are you not? By the way, my firm actually wrote to Professor McCarthy and asked him to add a section to his treatise addressing this very question. But unfortunately, spoiler alert, he said it depends. So no real answer there. What if the goods are offered not on the manufacturer's own, customary retail stores, but they're being offered on third-party online sites like Amazon or something like that? Does it matter if the sales are in like the traditional retail channels versus online marketplaces? There's no bright line rule. Are goods that are offered online in a foreign currency, but that can be shipped to the US in use in commerce? I encounter questions about whether something qualifies as use or is recent enough to be claimed as use, or whether the use matches up to something that's listed in the registration, probably on at least a weekly basis. And I've been practicing for like 23 years. There's a lot of questions. It's not, necessarily so easy to know if the claim is proper. And also, use in commerce can depend on the particular industry of the goods and services. Another reason that people might claim something but then not be able to provide the additional proof of use is that they have use, they're using the mark, but they're not able to provide a technical specimen of use that satisfies the USPTO's fairly strict requirements. So I put in the slide here the rule that says what a trademark specimen is. So Rule 2.56b, 1 is a trademark specimen must show use of the mark on the goods, on containers or packaging for the goods, on labels or tags affixed to the goods, or on a display associated with the goods. To constitute a display associated with the goods, a specimen must show the mark directly associated with the goods, and such use must be of a point of sale nature. The office may accept another document related to the goods or the sale of the goods when it is impracticable to place the mark on the goods, packaging for the goods, or displays associated with the goods. And let me tell you, that's a very high standard. That's like if you're shipping coal in rail cars. I mean, they consider that most things can be put in some kind of packaging. For services, a service mark specimen must show the mark is used in the sale of the services, including use in the performance or rendering of the services or in the advertising of the services. The specimen must show a direct association between the mark and the services. And frankly, trademark owners don't always think in those terms. They think about their business and the services they offer and what value their customers receive from them. But they may not be able to tangibly point you to something that satisfies one of these requirements. Okay, another reason that I think that mistakes may be made in filing the Section 8 is that the USPTO's electronic forms are, in my opinion, pretty difficult to navigate and follow. They are not intuitive in the least. And I think that it's very easy for people to inadvertently state something or claim something or not realize that they were supposed to have done something to delete things before they press the button to submit. I think another factor is that attorneys may be reluctant to press the client to show evidence of use for everything, since only a single specimen is required. It's expensive to go back and forth with your clients about whether something's in use, and it's expensive to go to the exercise of collecting specimens of use for everything in the registration, and attorneys may fear just alienating a client. Another factor is that our practice in the US is very different from the rest of the world. In the rest of the world, use is not required to obtain and maintain trademarks. And it's typical to have a registration that covers a broad list of goods that goes far beyond what the trademark owner itself might be doing or offering, so as to give broad protection to the registrant. They kind of make a defensive line around their area of interest. So in most of the rest of the world, this idea of having to be so specific about exactly what you're doing and to be able to provide a technical specimen of use to prove it is very foreign to those practitioners. So in my opinion, the vast majority of people just don't realize their mistakes. They don't understand the rules, but they don't have any intention to defraud the USPTO or to improperly create deadwood on the register. Now, unfortunately, I think after seeing the results of the pilot program and some other things that are going on in prosecution of trademarks in the US, I think the USPTO has become a bit defensive and views these false claims with great suspicion, like everybody's trying to pull a fast one, and maybe some are. However, the USPTO had a bunch of roundtables and forums with stakeholders over the course of several years after the results of the pilot program to talk about what to do. And in the course of that, attorneys were able to say things to them about all the reasons why mistakes may be made or that people don't understand, all the things that we just went through. people also said, look, just because someone gets an office action and doesn't answer it and doesn't send you the additional evidence, it doesn't necessarily mean they didn't have the use. It might just mean they don't want to spend the money to pay their lawyer to respond to the office action. So they heard that. And in general, I think that the kind of compromise position that they came up with that we'll be discussing, was a sensible, practical way to proceed. So some of the other issues that were considered in some of these roundtables and forums were, should the USPTO require a specimen to be submitted for every single item for which use was claimed? I put my hand up, no. Trademark practitioners told the USPTO that a requirement to submit a specimen for everything claimed would be very burdensome and expensive for registrants. The USPTO also said that it was not presently staffed to evaluate the sufficiency of specimens for everything in the registration. But the idea of continuing a random audit was generally supported by stakeholders. So that's the decision that was made. Of course, the devil's in the detail of exactly how they're going to, I'm seeing a question over here. A lot of your questions I do address later on, so we will be getting to most of those. The devil's in the details, exactly how is the audit going to be carried out, what are the requirements going to be, et cetera, et cetera. So the program was launched in November 1, 2017. It says a registration is subject to random selection if the registration includes at least one class with 4 or more goods or services, or at least 2 classes with 2 or more goods or services. And the rules provide that the USPTO may require the owner to furnish information, exhibits, affidavits, or declarations, or additional specimens, as may be reasonably necessary to the proper examination of the affidavit or declaration under Section 8, or for the office to assess and promote the accuracy and integrity of the register. There's that term again that we see so often. And this additional evidence is called proof of use. So proof of use is different from a specimen of use. There it goes. For goods, evidence showing the mark is actually used in commerce with existing goods will be required. So photographs that show the mark on a tag or label that's actually affixed to the goods and not just a tag or label that's submitted just separate and apart from the goods. Web page printouts or screenshots that show the mark being used in connection with the goods at their point of sale in a manner that directly associates the mark with the goods, and photographs of the mark on packaging where the goods are visible through the packaging. Those were some examples that were given of what would qualify as proof of use. I can tell you from my own experience, early on I had a case where the goods were computer software for use in positive pressure therapy. So I had submitted a specimen that was the actual disc. This was back, and the client still was making discs that you put into a piece of hardware, and it had the mark on it, and that was sufficient to be the specimen. But for the proof of use, they wanted proof that that software, in fact, was used in positive pressure therapy. So I had to go beyond just showing them the mark on the goods, and I had to submit, and what I did was I submitted the user manual that talked all about what the software was for. For services, evidence showing the mark is actually used in commerce with existing services, such as copies of advertising, brochures, flyers, where the mark is used in a manner that directly associates the mark with the services, photograph on retail store, restaurant signage, photographs of the mark on service vehicles, screenshots of website printouts with the URL and data printing, where the mark is used in the actual sale or advertising of the services. And the requirements for proof of use for services are very similar to what the requirements are for a specimen. It is still the case that only a single specimen of use per class is required to be submitted with the initial filing. Registrants who voluntarily submit specimens for all of the goods and services in their initial Section 8 in the hope that, oh, well, if I give them everything up front, maybe I won't be audited and I won't have to go to the expense of dealing with another office action. They can still receive an audit office action because the audit requires proof of use, which is not the same as a specimen of use. For multi-class registrations with classes containing only one product or service, proof of use will only be required for that class if the specimen is not also an acceptable proof of use. Sorry, I'm just checking the time here. Okay, so an example that the PTO gave, and they did have an online webinar about the new post-registration program. It is in your materials. I'll provide a link to it a little bit later. But they gave the example of the difference between a specimen of use and a proof of use by saying in a multi-class registration, the only goods in Class 18 are suitcases. So the specimen is a photo of the suitcase engraved with the mark. So no further inquiry is required because this is also acceptable proof of use. But if the specimen submitted with the Section 8 declaration is a photo of a hang tag with only the mark shown and not the underlying product, then that would receive an office action and the registrant would have to submit additional proof of use. If selected for audit, the office action will specifically say which additional 2 items in each class are the ones that they want to see your additional proof of use. You don't get to pick. And when they say items, they are not talking about what appears between, let's say, the semicolons in a long list of things. They're talking specifically for each item listed, even if it's within a longer clause. See, lots of good questions here. I think a lot of, oh, sorry, there's the 18. I think I see a lot of the stuff that's coming up. Okay, the office action will advise trademark owners to delete the goods. So here's where I felt that they were quite practical. If the registrant is not able to provide the proof of use, they're going to let you delete those items from the registration. You're not going to lose the whole registration. They're not going to say you committed fraud. But they do say also delete anything else that you are not using the mark on, because if you have to delete, you're then going to get a second office action that requires you to provide proof of use for everything else in the registration. So that can be extremely burdensome. If no response to the office action is filed and a fresh Section 8 is not filed before the end of the grace period, then the USPTO will cancel the entire registration. So that gets to the idea that you're allowed to file more than one Section 8 during the relevant time period. But if you, instead of responding to an office action, you opt to instead file a new Section 8 where you've maybe deleted everything that you should have deleted the first time, the registration is still subject to the audit because it was the registration that's being audited, not that particular filing. So even if you do a replacement Section 8, if you still have enough time left in the period, you're still going to have to provide proof of use for the 2 extra items and maybe everything. The deadline to respond to the office action is whichever is later of 6 months after the issue date of the office action or the end of the statutory filing period, not including the grace period. The owner must sign a declaration, and this is a slightly different declaration than the one that appears in the Section 8 and all the other forms that we regularly provide to clients to sign. It says the owner or holder was using the mark in commerce on or in connection with the goods and services identified in the registration for which use of the mark in commerce is claimed, as evidenced by the submitted proof of use during the relevant period for filing the affidavit of use. What's the relevant period? It's not defined. I don't know what it is. I believe it is the 18-month period during which the Section 8 was due to be filed. So the year prior to the filing date, either 6th year, 10th year, 20th year, et cetera, plus the grace period. I believe that that's the case because I've put that question to officials at the PTO in the past, at some of these forums that we've been talking about and other during their webinar that they had. And they've confirmed verbally that yes, use during that 18-month period counts. But there's nothing in writing that confirms that. So if the registrant doesn't provide satisfactory proof of use for each queried item, then a second office action will issue requiring use for all the remaining goods and services. To avoid issuance of a second office action, the registrant must delete all goods for which it cannot establish proof of use. If no response is filed to either the first or the second office action, the entire registration will be canceled. And here's a link to the PTO seminar. Again, the printout from it is included in your materials. And subsequent to the time of that webinar, the USPTO has also clarified, I think I heard this in a talk at another conference, they would like you to be very specific and clear about what the proof of use is that you're filing and exactly which item that they queried that it matches up to. Because it's not always crystal clear and apparent to them how what you're giving them shows use for whatever it is that they have asked. Also included in your materials is a USPTO FAQ that you can find on their website that has more details about the program, and also the initial Federal Register notice when they made the program official. So what are the results of the permanent program so far? Not good. I contacted someone at the PTO this week to get the latest and greatest statistics. They're in your slide here. Many people are still failing the audit. The results are largely consistent with the pilot program. So since November 2017 through September 30 of 2020, they've issued 12,740 office actions or first actions. They received 9,219 responses. Of those, 4,759 of the responses deleted goods or services or classes in the response. 52% of registrations where the person filed a response deleted at least some goods and services. So that's actually, I think the pilot program average was 51% of all the 500 registrations, and so it's actually worse now. And the worst thing is that 81% of the respondents were represented by an attorney when they filed the initial declaration. So at INTA 2019, then Commissioner Dennison announced that they were increasing the number of registrations audited, and we're going to audit 5,000 registrations in FY 2019. Of course, we're now past even FY 2020. I don't know what the goals are for the current fiscal year. Now, I think that this shows us is that there needs to be some education among the bar, which is why I've been really pressing and I asked Nahal if I could speak on this at this conference, because I think, as I said before, I think a lot of it is just not knowing all the requirements, not being aware of the program and its requirements and how to prepare for it, et cetera. But all of you now will be fully prepared once we get to the end of this. We're not there yet. This next slide also breaks it down by what the initial basis of the registration was. So 52% of registrations initially under 1A, use basis, filed a response that deleted goods and services. 69% of registrations originally based on 44E deleted goods and services. 70% of Madrid Protocol registrations deleted goods and services. And 68% of combined use and 44E registration basis filed a response deleting goods and services. So obviously, some work needs to be done to educate attorneys and registrants so that the registrants can be prepared to pass the audit. Okay, so how do we do that? Well, we've got to let the clients know that this program exists and that they need to pay careful attention to the declaration of use that they're signing. Inform them about the new audit program. If their registration meets the requirements, if they have a registration that has less than 3 goods in one class and no other classes, they're not even eligible to be audited because they didn't meet that threshold of 4 goods in a class. Explain that if the registration is selected for the audit, they will face additional expense for responding to the office action. So it pays to be very attentive now. That's something that I find clients pay attention to. Remind them that the signer is subject to criminal penalties for knowingly and willfully making false statements or representations. And the PTO rules say that whoever signs the document, and in my case, it's always the client, never, ever, ever do I sign these things. The signer is certifying that to the best of their knowledge, information, and belief formed after an inquiry reasonable under the circumstances, the factual contentions have evidentiary support. Now, if you were on the OED program yesterday, did you notice the part about how he talked about the PTO considers that requirement to also apply to whoever's filing the document? Even if you're not the one signing it, by filing it, you are also verifying that you're in compliance with that. We'll talk a little bit more about that later. Okay, so some of the things that you can do is to encourage the applicant to provide an image or online link to every product and service, such as in a chart or table. So rather than sending them the narrative that lists all the goods and services with the various commas and semicolons and all that sort of thing, make it into a table or chart where each thing is listed on its own line. Add an extra line that says fill in yes or no. Provide me with a URL. Now that's easier for some clients to do than others. And so you have to sort of customize it to the kind of client it is. But anyway, definitely engage with them and encourage them not to view this as just a yes, let's just get it done kind of thing, but something that they really need to take some time and document. File early so there is time to gather proof of use later if the registration is selected for audit. Now, filing early, I know that that's easier said than done. Many of us are filing these things in the last week before the grace period deadline. Not necessarily our fault, but the client's fault too. But in any event, if you file early, the advantage there is that you have the entire relevant period in which to come up with this proof of use that's required. So even if you didn't preserve evidence when you filed the first Section 8, like if the client said, yes, I have use for all 10 of these things, here's the one specimen, and you confirmed and you were confident that yes, they had it, but they didn't make a picture or a screenshot of everything at that time, then you can now, create the additional proof of use after you get the office action because you're still within the relevant period. It's sort of like how when you have to file your allegation of use after the notice of allowance issues, and if the specimen is not accepted, you have to put in a substitute specimen that dates back to the final date before you were supposed to file the allegation of use. This isn't quite like that. You have more time if you filed early. Also, filing early, you have an opportunity to file a second replacement Section 8 if that's the decision that you make. In some cases, with a small number of goods and services, it may make sense to just go ahead and gather the proof of use for everything in the registration. Also, if you have a client who doesn't mind spending the money to gather that evidence, just so they don't have to worry about it later. And you can either submit everything with the declaration of use or just have it in the file, ready to prepare that response to office action in case you get an audit office action. And be willing to press the client to justify its claimed use. I send foreign associate law firms that we deal with a one-pager about the audit program. I need to update it with the statistics I just got this week. And I explain to them, why this is important in the US, why the client really needs to pay attention. We're not like the rest of the world. And here's what the statistics are showing and the number of people that aren't able to pass this audit. And they've told me that it is really, really helpful for them to have that information to pass on to their clients, to explain to them why it is that they're pressing the client, so hard on this stuff. Okay, now you may want to make some strategic decisions along the way. I am very aggressive about suggesting deletion of any synonymous or overlapping identifications. So for example, the registration covers handbags, purses, and shoulder bags. I'm going to be like, just pick one. You don't need all of those three things. The Trademark office will refuse registration to purses and shoulder bags if all you have is handbags. So why do you need those additional terms? Shirts, t-shirts, and tops. I'm going to keep the tops, get rid of the shirts and the t-shirts. They're covered by the tops. Non-medicated skin cleansers, but you've also got shower gel and body wash. Just get rid of the shower gel and the body wash. Non-medicated skin cleansers covers that. Same thing with bed linens, but you've also got bed sheets, duvet covers, and shams. If you've got beverage ware, stemware, wine glasses, drinking glasses, all the same thing, people. Just go with the beverage ware. Cosmetics is sufficiently acceptable. You don't need to identify all of the mascara, the foundation, the blush. So in my opinion, all of the above examples identify essentially the same goods or goods that are within the scope of a broader term. And you may actually get it down under the four items that will make the registration even qualify to be audited. I saw one case because I've been tracking what's been going on with these. And this was a Class 10 registration, and it recited in Class 10 surgical apparatus and instruments. That term is acceptable in the U.S. Official Manual of Acceptable Identifications. You don't have to say anything more. But in this particular case, the registrant had then gone on and listed 22 separate types of surgery. So they had surgical apparatus and instruments for use in heart surgery, surgical apparatus and instruments for use in brain surgery, on and on and on and on. And when some of those specific articles, specific types of surgical apparatus were queried, they weren't able to provide proof of use that their apparatus and instruments were used in that particular type of surgery. Whereas if they had just said plain old surgical apparatus and instruments, they would have been covered for everything, and they wouldn't have had to deal with the problem of failing the audit and then having to provide evidence for everything left. Okay, I shudder to think about some of these software IDs that you see in Class 9, where it says, for example, computer software for the collection, editing, organizing, modifying, bookmarking, transmission, storage, and sharing of data and information. I am not eager to have to be figuring out how to show the PTO that the computer software does each one of those things. In some cases, yeah, if there's a user manual, like in the case I talked about before, that might be easy. But with some apps and stuff, some of this stuff happens in the background. You know, it's not that you can really specifically show the trademark office the mark being used in connection with that particular service. Now, when the trademark office was, you may know that they're in the process of circulating a new fee proposal. And they had proposed, because of the results they're seeing in this program, they had proposed to start requiring people to pay a fee to delete goods when they respond to the office action. Right now, that's not required. And they are thinking that if they start requiring a fee, that will be a further incentive to registrants to do the work up front and delete when they actually prepare the form, when you don't pay any extra fee to delete anything at that time. You just delete it. They proposed to charge a fee per good or service deleted. And I submitted that example of the surgery thing that I was just talking about to them to say, that seems like that person would have had to pay they were saying $100 per product and service. They would have had to pay $2,200 to delete every kind of that surgical apparatus and instruments that they had specified. And that seems somewhat inequitable, when if they had just done surgical apparatus and instruments, they would have kept that entire large scope of protection without having to pay $2,200 to end up in the same place at the end of the day. I've started adopting this. I've done this for several years now. I've started adopting this practice when filing new applications also. Familiarize yourself with the broad terms that are acceptable in the ID manual, and use those and only those if you can. For example, there's a lot of something wear IDs in Class 25. Sleepwear, loungewear, ski wear, swimwear. There's a lot of things like that where you can use that term and you don't have to drill down and identify 4 or 5 specific things that fall under that category. But the protection you're getting is just as strong. And then in terms of counseling our clients, we frequently have to make a call about whether marginal uses are sufficient or whether certain factual circumstances qualify as use in commerce. And when there's no case law, and there's not very much case law in specimens at all, we have to stick our necks out and give an opinion, and it's uncomfortable. I sort of go by the rule, when in doubt, delete, because the client can always refile on an intent to use basis for something. And certainly if it's a synonymous term, like we talked about earlier, there's really no material effect to deleting, something that's already covered by a broader or synonymous term. We try to explain, especially to foreign applicants, that in the US, less is more. You have a stronger enforcement right in the US if you have a registration that is solidly based on use. If you have a registration that includes a whole bunch of stuff that you're not using on, that is not a strong right to go trying to be challenging people with, because they're going to turn around and challenge your registration as being invalid on the basis that you filed a false declaration of use and you weren't using it for everything. So having a strong registration for, say, cosmetics, it's going to give you protection against all the goods that would be considered related to cosmetics, mascara, blush, the other things I mentioned before, without those things needing to be listed in the registration. It's different in other countries, where they want to see the specific good listed in the registration. So you have to work with people to really change their thinking about the scope of protection that you get in the United States. Now, sometimes the clients want to say, well, how can we just explain it to them? Can we just, first they'll say, well, can we just ask the PTO if this will work? No, they will not give you an answer if you ask if something would work, generally speaking. They say they're not allowed to give legal advice. In my experience, they are used to giving a thumbs up or down on whether the specimen is acceptable, and they're not really opining about whether the use shown in the specimen is legitimate or valid. They don't know if that perhaps that brochure was handed out at a trade show 2 years ago, so really it's not that current. So you certainly can provide a comprehensive explanation in the declaration of use of the exact circumstances the registrant is relying on to claim use. That might help you to feel that you're being transparent and forthright, and that's, I think, something to be encouraged. But just because your declaration is accepted doesn't mean that the USPTO actually gave any consideration to your explanation. Doesn't mean that they blessed it. And it doesn't prevent the registration from being challenged on the basis that the use you relied on was not, in fact, a sufficient use. On the fee proposal, I've heard that they will be implementing a fee to delete goods and services if you have to do that when you file a response to the office action. I haven't heard for sure. I think that they did away with the idea to do it per product and service, and I think it's going to be $100 for each class in which you have to delete something. I view that as positive because it's one more thing we can say to the clients, not just do you have to pay my fees to get the office action reported to you, figure out what to do, file the response, but now you're going to have to pay more in the official fees also. So pay attention to it now. Let's delete everything that you don't have use for or that we're not sure that you could come up with proof of use for that they'll accept were you to get audited. And that can be justified as being, very cost effective. So what is the practitioner's duty? At the OED yesterday, and as I mentioned previously, 37 CFR 11.18 says, to the best of the bracket practitioner's knowledge, information, and belief formed after an inquiry reasonable under the circumstances, allegations and factual contentions have evidentiary support. So what is an inquiry reasonable under the circumstances? Don't know. And I think the speaker yesterday also said he didn't know either. But his slide said that the OED, Office of Enforcement and Discipline, expects practitioners to, and these are his 4 bullet points, consult with their clients about the requirements for a valid specimen and use in commerce, vet the specimens prior to submission, ask questions, and if unsure, ask for better proof. Now, I'm completely on board with 1 through 3. Definitely going to consult with my clients, let them know what the requirements are, evaluate the specimens they provide and the circumstances they describe to give them advice about whether they can validly file the document. I'm going to ask them questions. I have no problem saying, you say it's in use for X and Y. I don't see those things on your website. Show me where I can find those. And sometimes they do, and sometimes they then agree to delete it. But some things, there's not a website for everything in the world. You don't. So you can't, in my opinion, it's really hard for me to completely vet everything that the client is saying. And ultimately, I've advised them. I've told them the potential consequences. But it comes down to them making an informed decision and deciding to sign the declaration. On his 4th bullet point, which was if unsure, ask for better proof. This to me raises a practice problem, because if you've got a valid specimen and that's what's sufficient to prove use, then should you really keep pressing them to provide the proof of use when you don't know that you're going to be audited? I think that those are tricky questions. Oh, and look, here's my client, Nahal Madani. Hey, how you doing?
Hi, Allison. How are you?
Good. So you got my email about your registration for alt legal that's coming up for Section 8 filing?
I did.
Great. And you pointed me to your website, and that alt legal legal docketing software, it looks fantastic. Congratulations on that.
Thank you.
I might have to look into it myself. That's going to be a perfect specimen for the legal docketing software that's in your registration. But the registration also covers interior design services in 42. I don't see anything on the website about interior design services.
Oh yeah, we do that.
Okay, great. Can you send me a website link showing that use?
It's not online. It's a bespoke service.
Can you send me like a brochure or something else that promotes those services?
I would, but I can't right now. I'm hosting my company's inaugural conference, so I'm kind of busy.
Okay, so you're telling me that you are definitely providing interior design services under the alt legal trademark.
And look at all these drawings that I have right behind me. They're custom art pieces. We're good.
Okay, and even though you don't have time to provide me with evidence of use right now, you could do so if the USPTO asked for that later, right?
Yeah, no problem.
Okay, you also have to sign a declaration of use under penalty of perjury that you are offering all the services in the registration. And this is the same statute, federal statute, that Martha Stewart was convicted of violating and for which she went to prison.
That's not a problem. Just send it to Bree. She'll get it signed for me.
You have to sign it yourself.
Sure, absolutely. No problem.
Okay, great to see you. We'll
Thanks.
get that over.
Thanks, bye.
So Nahal was kind enough to do a role play with me to kind of go through the challenges that we face in trying to convey to our clients the importance of this, try to gather the information, try to press them. But it's challenging. I think when INTA talked at 2019 about the new rules and how the program was working, they made some noise in their written remarks, in their verbal remarks, not in writing, that perhaps clients who file a lot of declarations of use that end up getting audited and that fail could possibly be referred to OED for action. I have no idea if that's happening. I don't know that I would know that that was happening until there was actually a decision or something about it. But practitioners said, but how are we supposed to defend ourselves? I mean, our communications with our client are subject to the attorney-client privilege, and that is the client's privilege. It is not our privilege. I can't send you the chain of emails that I had with the client, telling them about, where I pushed back, where I challenged them, and what and showing that I told them what the rules are and what the requirements are, and that they needed to be sure, and that sort of thing. So that's just coming forward. We'll see if things come out of that. But in any event, I hope that with this information, you'll feel like you can, now be educating your clients about it and thinking kind of strategically and proactively to be prepared to pass the audit. So I'll look at some of the questions now. Someone says the new fees will go into effect on January 1, 2021. I'm not really sure. I heard that Commissioner Gooder announced at an AIPLA meeting that I did not attend last week that they were expecting to go into effect in January 2021, and that a Federal Register notice to that effect would be coming out, but I don't know the exact date. And I imagine that I imagine there has to be some time after the Federal Register notice. I'm not really sure. So let's see. I'm going to go back up to the top so we don't miss early questions. As a best practice, is it better to submit a specimen for each product or service listed on the registration for Section 8 filings? I really can't. I don't know. I mean, if you have 50 things, I can't say it's a best practice to spend the money to come up with proof of use or a specimen of use for all 50 things. I think I had mentioned, though, that, if you only have 3 or 4 things, yeah, sure, maybe. But as I said, you can still get audited, even if you submit a specimen for everything, if the specimen doesn't also qualify as proof of use. Okay, let's see. Somebody said I've been getting these more and more for domestic clients. I wanted to do a poll and ask how many people have gotten them, but they told me that the poll only works if you're inside this particular platform. This person says, I'd love to know how outdated goods are handled for certain classes. For example, in class 9, for sound recordings listing cassette tapes, ringtone CDs, etc., for which there is no use, which has been replaced by downloadable sound recordings, MP3s, but the spec does not list MP3s. And ultimately, it's not proof of use for the listed goods, but still use on new and relevant medium. Okay, I'm glad that question came up, because the PTO actually does have a pilot program that allows you to amend your registration to change obsolete technology to new and modern technology. LA, do we need to let you do your magic and give us the CLE code?
Exactly. I think that's, exactly. Quick one, guys. CLE code is D like descriptiveness, W like WIPO, number 7, number 8, and then number 4. So that's DW784. I know, Allison, we're all excited to get to your questions, so I'll pop back in, towards the end to wrap things up and give that code again, but jump right back in. Thanks.
Okay, so this was an early question. I think I probably addressed it when we were talking about the synonymous goods. This person says, say you've got a brand new client, they have an old registration, you're working on Section 8, they have t-shirts, tank tops, button-down shirts, but they're no longer selling blouses that's in the registration and maybe long sleeve shirts. Do I really have to advise them to drop those other 2, what I would consider related / subset items? Yes, the answer is yes, because if the trademark office requires you to give them a picture of a long sleeve shirt and they don't have one, then that's going to be a problem for you, and you're gaining absolutely nothing by keeping that in there, because they're going to have plenty of protection with these other terms. Now, when I say you have to do it, of course you don't have to do it, but I'm telling you what I would do. I get they're no longer selling pants, and those should be deleted. Just unclear sometimes on where to draw the line. I'm very strict, and I will go after those synonymous goods listings. Like, that's the first place I start cutting. I take the red ink and I'm like, this is going, this is going, this is going. In part just because, it's going to make your job easier if you do get a post-registration audit. Somebody made the comment that the numbers really drive home the point from yesterday's ethics CLE about not signing use declarations for your clients. Absolutely. Never, ever, ever do I do that. Somebody says, I note the audited marks do not even have a long list of goods. And that my declarations and renewals were otherwise accepted. I'm sorry, I don't understand that question. Okay, client's favorite question. So if I ship one or sell one to my friend, does that count? Yeah, we all get that question. So you have to go back to the part of the statute that says that the use has to be in the ordinary course of trade and not made just to reserve a right in a mark. Sounds to me like selling one to your friend is not the ordinary course of trade, so that probably doesn't count. If you ship one and your business is such that you ship one shirt a year, that is the ordinary course of business for your business, then maybe that would count if it was an arm's length sale. Doesn't sound like you have a super successful business worth paying to maintain your registration, but that's what the definition is. So you have to interpret that for your situation. This person says, good questions on what constitutes use. Any specifics or examples you can provide would be great. Well, I get questions like, our registration covers lingerie and we have a sports bra. Does that count? I don't know. I mean, I think of lingerie as not being like a sports bra, but they're both a foundation garment worn under other clothes, maybe. That might be a case where, I put in the specimen of use that shows it's a sports bra, so the PTO can perhaps draw their own conclusions and tell me whether they think it counts or not. If I think of some more examples as we're going through, I'll try to come up with some more. Please expand on the related goods doctrine. Is that a non-estoppel argument? I'm sorry, I don't really understand that. And I think that question came in before I had covered that in the slide, so I didn't know if this was someone who was looking ahead. I mean, related goods doctrine basically means that in the US, your protection extends, your protection against other marks extends to related goods that consumers would think were coming from the same source. So your registration, it isn't just a matter of saying, here's what your registration covers, is that it? No, you have no protection. So if you have protection for a few articles of apparel, that's going to cover most articles of apparel. Maybe some specialized articles of apparel like wedding gowns, might not be covered by, but t-shirts, pants, all those sort of things are all considered related. When would a specimen of record not also be an acceptable proof of use? That's if you recall the slide that was talking about a specimen of use for a suitcase, where if it was just like the hang tag, but it wasn't affixed to the product, you just submitted a picture of the hang tag and it showed the mark on it. So that's the mark on the packaging. Okay, that's an okay specimen, but they want to see it actually used on the goods. So they would want a new picture that shows the goods like as they're actually sold with that packaging on them. The other example I gave was for the software where I put in the disk and it showed the mark on the disk. And but it didn't show what the function of that software was or the field that it was used in. So I had to put in the user manual that explained that, yes, this in fact is used in connection with this particular medical condition. Oh, hi, Nahal, I see your message now. I hadn't seen it before. Somebody says, I've seen more audit requests come through in cases where an amendment to the ID of goods or services was submitted in the underlying Section 8 filing. Have you all had a similar experience? I have not. I make lots of amendments to the ID, or mostly deleting stuff, and that doesn't seem to have any effect on whether I get audited. Somebody asked, did the USPTO mention how many registrations were ultimately canceled as a result of the program so far? Yes, I think that is somewhere in their statistics. Let's see, where did we get to with that? No, I would have to do like math. I'd have to take like how many didn't file responses and got canceled. And they don't really say how many people got a second office action and then either met the requirements of that or didn't. So I don't have exactly that, but if you hunt around on their website at the links that I provided in the material and the FAQs, there may be information there that you could figure that out, or they may say it. Regarding deleting synonymous goods proactively, in the post-registration audit, you could use the same specimen as evidence for more than one item. Yes, you can. Yeah. A tank top is also a top. A shirt is also a top. So proof of use for those things would work. And they acknowledge that sometimes your specimen of use is going to be basically the same, even though it's for a different product. Somebody asked if there will be new T's plus filing fees. Yes. I at least in the initial draft that they circulated, the T's, what they call standard now, was going to go up to, I think, $350 from $275. And the T's plus, I don't use that one, so I didn't pay attention. But yes, it is. I think it's $225 now, and I think it's going to go up maybe to $250, maybe $275. I'm not sure. Best method to have clients sign the declaration. How does this get done through USPTO? Do you have to download the OBJ file? Yes. My legal assistants prepare. I prefer to use the T's forms, even though they're terrible. And I don't mind going on record saying that, because I've said that to them in the past, because I don't have to then check a separate Word document and then also check it after my paralegal transfers the information into T's. Now, I hear that Alt Legal has a fantastic system for preparing those forms, so I may need to dive in to start using it that way. Yes, and then, yeah, I see that somebody responded. Yes, the PTO has a function where you prepare the form, it generates a link, you send the link to the client with instructions on how to sign, they sign, it comes back to you, you file it. LA's back.
No, keep going. You've got more questions. I want to keep you as long as we can. So let's keep going.
It's just any way to amend an application after submission and before being assigned to an examiner. Yes, you go up to the T's forms, and there's a form called voluntary amendment not in response to an office action. And you can use that to make an amendment. For example, maybe you're uploading the signed declaration because you originally filed unsigned, or you want to amend the ID because you got a demand letter and you're agreeing to something. That's the form to use for that. Why don't I use T's Plus? T's Plus is very, very strict in terms of the requirements, and you can fall out of T's Plus status for some unexpected things sometime, like you didn't put in a translation that in your opinion shouldn't have to be put in, or something like that, and then you have to send the client a bill for $50 more later, and it's just administratively awkward. You also have to pull ID from their approved list, and a lot of times we don't want to use their approved list. For example, we might start with a broad term that we know the USPTO will require more specificity for. It's still accurate. I mean, it's still what the client has a bona fide intent to use for, and maybe they want to file a Madrid protocol based on this US one with the broad language, because the broad language is accepted in most other countries. And, so later on we'll have to amend it down in the US, but we can't use T's Plus to use that broad ID because it won't let us pick that off the list. Yeah, I should use the Alt Legal form. I know, you're right, I should. One of these days, right? Okay,
exactly.
So that looks like the end of the questions, unless anyone has anything else. I'll be at the happy hour tonight, and if anybody thinks of more questions in the meantime, I'm happy to talk about it. And if you have any great tricks and tips to get your clients to be totally responsive and to provide you with all the evidence of use, please share them, because as you saw with my client Nahal, who thinks he's really going to be able to prove use for interior design services? I mean, to me, those look like his kids' drawings on the wall. But again, who am I? Maybe, it could be Jackson Pollock for all I know, right? So I don't know.
We did have one more question come in, Allison. Lori Epstein was wondering about the amendment of an application before it's removed. Can you do it for a non-material alteration of the mark?
I think she means before it's examined. Yes, you can. Yep. Yeah, you'll have to check a box that says you acknowledge that the PTO is going to have to make a decision about whether they think it's material or non-material, but that's fine. If you think it's non-material, you can do it even if it's material. It's just that when it gets to the examiner, they'll have to make a call.
Great. Well, Allison, thank you again. This is amazing. Always really informative. As she said, come find her at the happy hour, chat with her if you have further questions and want to discuss more. We always encourage that. Again, super helpful. Up next, we have our coffee masterclass event starting at 3 p.m. Eastern. If you don't feel like attending, no worries. Our next session, Creating a Client-Centered Law Firm, will begin at 4 p.m. Eastern. You can join our networking event and the session by going to the schedule page in Umbrella. So I don't forget, here's the CLE code again. It's D like descriptiveness, W like WIPO, 784. That's DW784. Thanks again for listening, and we'll see you soon. Hopefully, to be nice and caffeinated.
Thanks, everybody.
Thanks, Allison.